You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 117, What Happens at a Patent Trial. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's DIAMENT patentlaw.com, or call me at 424-281-0162. This is probably going to be the last episode I do about patent litigation, with maybe one more episode about a special kind of litigation that happens at the International Trade Commission. So far, I've covered the basics of a cease and desist letter, a complaint, responding to the complaint, scheduling, shifting the case back to the patent office in some circumstances, various types of motions like summary judgment, and discovery. In the last episode, I covered discovery, and maybe I didn't make this entirely clear in the last episode, but discovery is where you're gathering evidence that you're going to present at trial, and there are basically three kinds of evidence. There's written evidence, like written answers to questions in interrogatories and requests for admissions. There's oral evidence, which is what you gather at depositions, and there's physical object evidence, which would be the type of evidence you get if you do a request for production of documents. So now you need to tell a story to a jury to make your case or tell your story by bringing witnesses. Really, a patent trial is not actually any different than any other type of civil trial. If you're the plaintiff, you want the jury to say that the other party infringed your patent and they owe you monetary damages. If you're the defendant, you want the jury to say that you did not infringe the patent holder's patent. And what the jury says is called the verdict. So let's go through the steps, and this is really a broad overview. Each one of these steps can take several days to go through at a trial. So now getting to the actual stage of the trial is actually pretty rare these days for lots of reasons that I've already talked about. It's very expensive for both sides, so people just want to settle early. Also, there are parts in the litigation process that make it much more likely for both sides to know who is likely to win because of what are called Marksman hearings, which I've talked about before. Marksman hearings are where a judge has decided on the meaning of words in a patent claim. For example, if one party says they're not infringing because the patent requires a tunnel, but in your product you don't have a tunnel, you have a groove. If the judge has already ruled that a tunnel doesn't have to be closed on all sides, and that a groove is a type of tunnel, then you already know who's likely going to win because that's the definition that's going to be used. So one side will settle just knowing that. Now you might be thinking, well, doesn't the jury decide what a tunnel or a groove means? And the answer is no, and that's because of how our judicial system works. Judges decide questions of law, and juries decide questions of fact. When an attorney says, objection hearsay, each jury member doesn't get to chime in and decide whether they think it's hearsay or not, because that's a question of law that judges decide. It's the same thing with definitions of words, and maybe that doesn't make sense or you don't agree, but it's been determined that the definition of words is not a question of fact that the jury gets to decide. It's a question of law that a judge decides when those words are inside of the patent claims. Anyways, after all the definitions have been decided, there can still be certain questions about facts that have happened because the two sides may disagree on certain facts. If you remember back in my podcast series, I talked about required parts of a patent and what an invention has to be. One thing is that the invention has to have utility. That's a use. One side is going to have an expert saying that there's no utility, and the other side is going to say that there is utility. Also, whether the patent application has a proper written description is something that's considered a matter of fact. How much damages there are is also going to be considered a question of fact, because that's often based on what a reasonable royalty would have been. And the jury will hear from different experts on what a reasonable royalty would have been in this case to determine what damages are. Anyways, there are lots of facts and lots of issues of law during trial that either the judge has to determine or the jury has to determine based on whether it's a matter of law or a matter of fact. Now, even though it's rare for patents to go all the way through trial, occasionally they do. I saw one statistic, and it might be a little bit old, but it's that of all the patent cases that were filed in court, only about 2% actually made it through to trial. But let's say you've made it all the way there. What happens? Well, one of the first things that you might want to do is start at the end and work backwards. And this is when preparing for trial. What's at the end of the trial? At the end of the trial is when the jury has a set of instructions for determining whether or not there's patent infringement and how the damages are calculated. Now, you should already know what patent infringement is, but take a look at the jury instructions. This is what the jury is going to be looking at. The jury instructions are going to say, patent infringement has occurred if the defendant has done A, B, and C. So when preparing your case, if you're the plaintiff, make sure that you provide all the evidence that the defendant has done A, B, and C. Or if you're the defendant, make sure that you present evidence that either A, B, or C hasn't happened. There might be lots of different jury instructions, but when preparing your case, you want to make sure that it's easy for the jury to find in your favor. So make it simple for them to understand that either what they've done is covered by A, B, and C, or it isn't covered by A, B, and C, whatever you're trying to prove. So let's say you've prepared your case well, you're in the courtroom, what do? The first thing is jury selection. Now, you actually don't have to have a jury in a civil patent trial, and you can have a judge do the whole thing. But if you want a jury, you can have one. And I read a statistic that 95% of patent cases are tried by jury. Picking a jury is called voir dire. Typically, there are going to be 12 members of the jury. It can be as few as 6 according to the rules, but most of the time there's 12 on the jury. Each side gets to exclude a certain number of jurors. So they can excuse or eliminate them from the jury panel. If it's really obvious a juror is going to have bias, you can excuse them without it counting against you for your number of juror challenges. Let's say one of the members of the jury panel used to work at one of the companies. They probably shouldn't be allowed to be on the jury because maybe they already have insider knowledge on the invention, or they have a positive or negative bias against one of the companies. So let's say now that you have your jury panel, what happens next is probably what you've seen on TV or movies for any other kind of trial. Each side is going to make opening arguments. Each side is going to present witnesses, and the witnesses give oral testimony. And if you want to produce physical objects, you have to have a witness with knowledge of that object to be able to say what the object is, and then that's entered into evidence. Each side is going to have expert witnesses, probably explaining different things about the technology of the invention and what the patent means. You're going to have witnesses giving evidence about how much financial damage there was or wasn't. And at the end, each side is going to present closing arguments. The judge is going to read jury instructions about what patent infringement is, how to calculate damages, and it could be lots of other things. The jury will go back into a jury room and try to come up with their conclusion on whether what happened counts as patent infringement or not. Civil cases, such as patent cases, are not criminal cases, which means that the plaintiff does not need to prove their case of infringement beyond a reasonable doubt. In civil cases, you just need preponderance of the evidence. That means that the jury just has to decide whether it was more likely than not that there was infringement. So if you think that there was patent infringement, but you're only 50.1% sure, then you have to vote for infringement. In a criminal trial, it's beyond a reasonable doubt. So if this was a criminal standard, you'd have to vote for non-infringement, because if you still have 49.9% doubt, that's still a lot of doubt. Patent law has another standard that isn't used that much. Most of you have probably heard of beyond a reasonable doubt, and many of you have probably heard of preponderance of the evidence before. But there is another standard that is not used for infringement, but is used to invalidate a patent. And that standard is clear and convincing evidence. If the patent office has granted a patent, you have to presume it's valid. But maybe you've heard a lot of evidence and you think that it should never have been granted. In order to invalidate the patent, it has to be clear and convincing that it shouldn't have been granted. And that means highly and substantially more probable to be true. There's no number that's attached to it, just like there's no number for reasonable doubt. The only evidence standard that there is preponderance, that has a number, is preponderance of the evidence, and that's anything above 50%. But personally, if I were on a jury and I was given the standard of clear and convincing, I probably would feel that I'd have to be like 80 to 90% sure in order, to meet that standard. That's not enough for beyond reasonable doubt, which in my mind is probably closer to 98, 99%. But it should be pretty clear, and to me, it's probably in the 80 to 90% area. But a lawyer isn't actually going to give you a number at trial. They're not allowed to. These are just kind of my own personal beliefs on how I would view these standards if I had to, put a number on them. So at the end of jury deliberations, the jury gives a verdict. It has to be unanimous. Now, just because the trial is over doesn't mean that the case is over. You might get a new trial if the judge is convinced that the judgment would result in a miscarriage of justice, or if there's new evidence discovered after the trial that couldn't have been discovered with due diligence before or during the trial. There's something called motion for judgment notwithstanding the verdict. That's when the judge thinks that the jury erred, and it so strongly favored one side that a reasonable jury couldn't have come up with a contrary verdict. Now, these are very rare, because the whole point of having a jury trial is that we leave things up to the jury. And for a judge to just come in and say, yeah, the jury gave this verdict, but I'm going to ignore it, I'm going to rule the other way, it just doesn't happen unless something really extreme and egregious has happened. There can be a motion to amend or nullify the judgment if the final judgment was obtained by fraud or ill practice. This doesn't really happen too much either. What does happen a lot, though, is that the case can be appealed to the federal circuit. I've talked about this before. Patent cases are not appealed to their geographic location like other federal cases are. Usually if you have a case in Los Angeles and you appeal it, it goes up to the Ninth Circuit Court of Appeals, and that's the appeals court that handles cases appealed in the Western United States. But patents are different, where no matter where the trial case happened in the country, it's appealed to the federal circuit, which is in Washington, D.C. And if you lose there, you can appeal to the Supreme Court, but the Supreme Court takes so few patent cases, probably less than 5 per year, that most likely your journey ends at the federal circuit. But the federal circuit may just kick it back down to the district court where you had your trial and say you need to do a new trial because the trial court, for example, used bad jury instructions or something like that. So they won't necessarily say who won, but they will say if there are any errors at the trial court and that it might have to be done over again. And even when that happens, you might just have an idea on who's likely to win at this stage based on the new jury instructions that you might settle at this point and you don't even have a new trial. But so many things are possible, so many twists and turns that you just kind of have to be prepared for, kind of the routes that cases can take through all the different types of courts that we have. And that's the basics of a patent trial. If you want help with your patent applications, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.